we discussed previous 2 days all types of contestations, backlashes, and now we will see where is the place for human rights in this changing context. And we will look in particular today to one institution I am very interested in. It's our sister, this is our brother institution in another continent, Inter-American Court of Human Rights, and also we will discover about the fate of indigenous people in Israel. I'll change also a bit of format of our panel. Floor for questions will be opened after every presentation, and at the end of the I will summarize and comment on all three presentations at the end of all our discussions. And we start with our first presentation by Ximena Soleil and Sylvia Steininger, who are both research fellows at the Max Planck Institute for Comparative Public Law and International Law, and they are writing their PhDs right now. And they will present a topic on inter-American lessons on backlash. So the floor is yours.
Hello everyone, welcome to the last panel. You nearly made it, congratulations. Before everyone is leaving to go out and enjoy the sun, which we don't have in Europe at the moment, Ximena and I will present you our paper on withdrawals, backlash, and the Inter-American Court of Human Rights. So this is the first change of the program is that we changed the title from our paper. We realized that identifying lessons is quite difficult, so in order to not put the paper in the bin, we just changed the title. So this is the one you see here. So the paper in a nutshell, to give you the gist of it, maybe if we're in Israel, the paper in an olive pit would be more appropriate. So a research question is actually quite similar to many of the questions we actually discussed in a couple of the last 2 days. And it links back into the early beginnings of this conference when Larry Helfer told us all about treaty exits and withdrawals. So we come full circle now. We were interested in the question whether withdrawings or threats thereof of a treaty can be amount to a backlash against a particular institution. So we're both working on courts, so we are looking at the most interesting, the most exciting and dynamic, no offense to the European Court, at the Inter-American Court of Human Rights. So from an empirical perspective, we focus on 4 case studies of at least attempted treaty exit. This includes the successful withdrawals of Trinidad and Tobago and Venezuela, as well as the attempted withdrawal of Peru, and the announcement to withdraw of the Dominican Republic. Of course, we do not claim that withdrawal is the only embodiment of backlash, but it's one which we can actually clearly identify and which is very severe and very visible. This also allows us to have quite a variance in our case studies. So we have democracies and autocracies, we have backlash attempts from every branch of the government, and we have successful and unsuccessful withdrawals from the court. However, we were also quite taken aback by the amount how backlash is used in the literature. So basically everything under the sun which is at least critical is now backlash. We don't think that's actually the case, which is why we have to differentiate it from other less severe forms of criticism. So that's the first attempt. So that's what we are proposing, the following backlash as a practice of criticism analytical framework, which we use then in the empirics, which is following 4 different practices of criticism which are not evolutive, so you can immediately jump to backlash, but you can also go through the stages if you want so. So they are organized along 2 lines, basically from severity, from the ordinary to the extraordinary, and from the object. So from a particular judgment on the left side to the challenge of the institution as such on the right side. So the dashed line in the middle is so the main objective. It's also along the special issue which Paula already introduced yesterday. There will be an introduction by Mikael Madsen, Paula and Mikael, which is following a similar line of reasoning. I'll just go a little bit through the whole 4 stages. The first category is objection, which includes all kinds of negative reactions to the work of a court. It's the bread and butter, so it's completely normal and usual that we have this kind as long as it remains rhetorical. So it's nothing to worry about, it's the bread and butter everyday life. The second category on the left is norm contestation and links to social constructivist research of IR theory, which identifies conflicts focusing on the application and interpretation of norms. So of course the theory stems from social science, so the word norm is used a bit different than the legal norm, but I think we see also instances where a relevant actor criticizes in international courts how a particular norm is applied or interpreted, or whether a particular norm is actually still valid. The third category is resistance. So we cross over to challenges to the institution. And it can manifest in public contestation or public non-compliance and non-cooperation. However, in contrast to backlash, the relevant actor still plays along to the rules of the game, so to speak. So he still is at least attempting to reform the court, basically. So it's a more constructive vocabulary to reform and challenge an institution. The last category then is backlash. And we follow definitions already presented yesterday. I don't want to recapitulate them. But for us, it's like systematic and consistent criticism, as well as severe instances of non-compliance, which are aimed not at undoing a particular ruling, but undermining challenges institution as such. So its structures and its powers, mainly. So that's our attempt at providing clarification on providing, we're hopeful, a helpful analytical framework for doing that, which is along the lines of several others' contributions, and we are very much looking forward to hear your feedback. But before we hear your feedback, we now go to the application, to Jimena.
Okay, so I'm gonna quickly, as quickly as I can, run through the case studies. So the very first experience that the Inter-American Court of Human Rights had with withdrawal, or threat withdrawal, was Trinidad and Tobago. This was in 1998. And this is a fairly straightforward exit that was mainly manifested as an issue of norm contestation. So it's centered basically on the application of the death penalty, not its general existence, because the American Convention of Human Rights does not ban the death penalty as such. And interestingly enough, the decision to withdraw was made before the Inter-American Court of Human Rights had ever had the chance to address the issue. And to some extent, to a large extent, it was due to the actions of a very different tribunal. So I'm talking here basically about the Privy Council decision in Pratt & Morgan versus Attorney General of Jamaica, which held that a wait of longer than 5 years in death row constituted cruel, inhuman, and degrading treatment, and that when this time frame was exceeded, then the death penalty would automatically have to be commuted to life in prison. The time frame, however, was too short for appellate and international review procedures to run their course. This would have meant, in practice, that the death penalty could never be applied. Trinidadian authorities, therefore, then asked the Commission for assurances that they would deal with these cases in a very fast manner, or whether they could deal with them in 18 months, and the Commission basically refused to give these assurances. Trinidad and Tobago went forward and denounced the American Convention of Human Rights, and since 1999, it's not a part of the convention. So we can see it was fairly easy for Trinidad and Tobago to extricate itself from the court. There was very little domestic opposition. The court was little known outside circle of abolitionist activists, and the court and the Commission had not really engaged with Trinidad and Tobago before. And we see the difference there with the Privy Council, because although the decision was very similar, Trinidad and Tobago never actually left the Privy Council. Now we move on to our second example, and that's Peru. And this was an attempted withdrawal, not an actual withdrawal. And in the decade sort of preceding this attempted withdrawal, Peru was in a very difficult situation. There were violent terrorist groups that wanted to install a communist regime, and then they elected Alberto Fujimori basically to deal with the terrorist threat. And he did this in very questionable ways. And not only that, he started to dismantle checks and balances on his powers. Dissolved Congress, dismissed judges, passed increasingly repressive laws, and co-opted the media. In due time, cases regarding these issues started to make their way to the docket of the Inter-American Court of Human Rights. Following two cases which were not popular at the time because they dealt with due process rights of terrorists, Fujimori kind of seized the opportunity and basically announced that it would withdraw the recognition of the jurisdiction of the court. So it would not denounce the American Convention of Human Rights, it would just withdraw this recognition, and he also said it would have immediate effects, and all the cases that were pending then the court would not be able to deal with them. So the international community had somewhat of an outcry, and there were also the domestic legal community and political opposition expressed their disagreement with this decision. on its part, what the Inter-American Court of Human Rights did, sort of to keep Peru under its jurisdiction, was to say you can't just withdraw the recognition of jurisdiction. You have to denounce the whole thing. This did not happen, however, because the Fujimori regime fell only a couple of weeks after this decision of the Inter-American Court of Human Rights was taken. What followed is interesting in the sense that the transitional government of Peru considered that regularizing its situation with the Inter-American Court of Human Rights was a central part of recovering some of Peru's reputational loss and in sort of signaling a break with the past. Now, the Peruvian decision can be considered an instance of resistance against the Inter-American Court of Human Rights. It's resistance because although the government raised points on certain norms, especially due process rights for terrorists, the criticism was actually directed at the institution. But Fujimori basically only wanted free reign to do whatever he wanted at home. There was not like a broader agenda to sort of undermine or weaken the Inter-American Court of Human Rights, so basically not backlash. All right. Now this is, we're going to deal with a weak version of backlash, and that's the Dominican Republic. Now, the Dominican Republic, and this is also an attempted withdrawal, and the status is actually quite unclear. The Dominican Republic has historically endured sort of a large influx of Haitian migrants, and it has a very large population of Dominicans of Haitian descent, and it doesn't tend to treat them particularly well. So you have mass deportations without any type of process. They make it administratively practically impossible for persons who are entitled to Dominican nationality to acquire it. And not only that, then the government decided to take another measure to deal with the problem, and it amended the constitution to substantially restrict the rules on acquisition of nationality. So what the Dominican Republic had was a system of jus soli, so basically all the children of the Haitian migrants would automatically be Dominican citizens. The issue reached the court, and then the court held that the Dominican Republic was actually in breach of its obligation to prevent statelessness. And this was not one of these rights that the International Court of Human Rights likes to create. This is an actual obligation in the American Convention on Human Rights, on paper. Why was the Dominican Republic in breach of this obligation? Because it could not really prove that Haiti could grant the Dominican-born children of Haitian migrants its nationality. So, the immediate reaction of the Dominican authorities was one of resistance. So they questioned the court's powers to render such a judgment. But the situation was exacerbated when the Constitutional Court held that the acceptance of jurisdiction of the court had not followed domestic constitutional procedures and was thus invalid. Resistance turned to backlash when high state officials openly called for the powers of the Commission and the court to be substantially weakened, and unsuccessfully attempting to reopen a recently concluded reform process. Now, the situation in the Dominican Republic is complicated. The American Convention of Human Rights has not been denounced, and as a matter of fact, it's still part of the constitutional bloc of that country. Okay, no. Not only that, but you have large sectors of the Dominican legal community that strongly disagree with this decision, and the decision of the Constitutional Court was also very much divided. And almost 3.5 years after the ruling, the situation seems to be at a standstill. The Dominican Republic has stopped appearing before the court, stopped providing information, and the Inter-American Court of Human Rights keeps on sort of considering it part of the court and asking it to please give this information. Now, let's move on to kind of the toughest case of backlash that the inter-American system has ever gone through. And it all starts with Venezuela. And this type of clash was very much ideologically based. So the Chavez regime in Venezuela claims to stand, for the so-called socialism of the 21st century. And the Inter-American Court of Human Rights, although it's progressive in its jurisprudence for the poor and the vulnerable, stands for the liberal world order. The instance of backlash was particularly dangerous and protracted because it garnered more sympathy and support among some American states, especially those with similar ideological leanings. So, how did it start? What happened was that a very large amount of cases against Venezuela also started making their way through the inter-American system, through the commission, through the court. Many of them concerned the lack of independence of the judiciary, so court packing, dismissal of judges, curtailing of freedom of expression, closing down of regime-critical media outlets, the persecution of political opponents. At the same time, Venezuela took out a conscious effort to undermine the Organization of American States. And it set up a series of alternative organizations in the Americas that more or less dealt with the exact same things, but without US participation. Also, sometimes without Canadian participation. There were several. So withdrawal took place in 2012, but the actual sort of hostile questioning of the system started already in 2008. And you also have a decision of the Constitutional Court also going back on its decision to consider the human rights law and the decisions of the Inter-American Court of Human Rights as part of its constitutional block. So it's kind of a permission also of the Constitutional Court to go ahead with the backlash, and the regime took it. So the commission was called the lackey of the empire, controlled by the US Department of State. Their actions were interventionist and politicized. Discontent grew, and other countries climbed on the bandwagon. So what happened then, there was a 2-year reform process of the inter-American system started. They called it the strengthening process. Everyone else who was observing the process knew that this was just a euphemism. But the problem was that many, many different states had beefs with the inter-American system for many different reasons. So they all went along with it. However, what happened? There was a period of sustained lobbying and outreach by NGOs, sort of lobbying diplomats at the OAS, sort of telling them what the benefits of the system were. Also, you had the stalwart support of some OAS members, especially Mexico, basically trying to stop other member states from climbing on this sort of court bashing. And at some point, more moderate states realized that they're about to throw out the baby with the bathwater. The system organs emerged on the other side more or less unscathed. So there were some kinds of reforms that took place, which are actually quite positive for the system, but this whole ideological shift never happened. Right, so I'd like to...
Yeah, so we just go to the last slide, the last 30 seconds. I can speak very fast, as you might have noticed. That's not a problem for me. Okay, but so as you can see, when we go back to our research question we have, is withdrawal a form of backlash? And actually the answer is, it is complex, or it depends. So we have instances where withdrawal actually happened, but we still say this was a question of non-contestation. It didn't hurt the court, it didn't question the powers or the structures of the court. However, we have instances of at least attempted withdrawal or open withdrawal, like the Dominican Republic, and it can still amount to a backlash, even though it's a weak version. So as always, things change and things remain complex, and we're looking forward to your questions.
Thank you very much for this extremely interesting overview. Actually, you reminded me how lucky we are for the time being for the European Convention of Human Rights. No withdrawal took place, and no state has denounced conventions so far. So, but we are in a bit more comfortable situation. So, dear colleagues, I open the floor for your questions and comments. Yeah.
I have a question for Jimena, actually. You said that Venezuela's backlash of the court is ideological. My interpretation might be a bit different. I'm a bit cynical. Do we really think it's an ideological problem with this, or just that, well, the regime doesn't like human rights, doesn't want to complain. So, well, yeah, call it a tool of the imperialism and whatever, especially a court that doesn't even involve the US. It had one US judge back in the day, Bogenthal, but the US is not even part of the court. So does it have anything to do with, it's a really ideological objection, it's just a justification for not complying with human rights. It's just a question.
Thank you. Let me collect several questions. Yes, I have.
Thanks so much. My question is whether your theory, your categorization is also applicable to other cases of objection or backlash. So, for example, how would you qualify the recent judgment by the Argentinian Supreme Court, which could be qualified as just an objection to a single judgment, but when you look at the judgment, actually the criticism goes much further than just against that judgment.
Thank you very much. I have Lawrence and then Christina. Yeah.
So I read the paper. I liked it very much. No surprise, right? Because these are things I've been writing about for a while. But what I think I would emphasize to you is actually what you didn't emphasize, which I think is really a serious good contribution in addition to this framework and typology, and that is the factors of the Inter-American Court's resilience. And I just invite you to say a couple of words about that, because I actually thought that there were some interesting points there about the way in which other actors can make the court more resilient. In particular, the Commission takes the heat because of its function, of investigative function, and issuing country reports. And so the court is shielded by the Commission, which no longer has been true for Strasbourg for some time, although even then it was a different Commission. But there are some other literatures you may want to engage in, specifically Stephanie Brewer and Jim Cavallaro in their piece in the American Journal about how that the Inter-American Court was not really engaging in civil society. So there's another strand of literature that says you say civil society are kind of helping to keep the court resilient. There's a divided view. So.
We left the chapter out from the presentation, but you can always get on SSRN, so it's online.
Thank you. Christina, please.
Well, perhaps there's also an answer to my question in your paper, because I haven't read it yet, so to say, but actually one important instrument to controlling institution obviously is a budget always. So I wanted to know, have you looked, and there are quite diverse informations out there depending on to whom you talk, have you looked into the financial resources, especially for the future years, in terms of Inter-American Commission or the Inter-American Court?
Thank you, and I think we have last question.
Yeah, I have a question which was solicited by my colleague from the European Court of Human Rights. It is interesting that in the inter-American system, at least some countries feel the pressure to actually withdraw, rather than going the petty, small way of non-implementation, conditional implementation, etc. In Europe, we have just the opposite. We have some countries, which I don't want to name now, but you know what we all have in mind, who seem to cherish to be a member of the convention without implementing the judgments anymore in a serious way, or procrastinating successfully, no more successfully than not, the cases, but are in material non-compliance, which is quite obvious. So actually, is there not something to commend the inter-American system for, to force states actually into withdrawal? Is it a good thing or is it a bad thing?
Well, thank you very much. We have quite good collection of questions. Now, Silvia and Jimena, the floor is yours.
So, there are not so many theoretical questions. I take that you all agree with my framework. So, I think that the Argentine case, I think like what we don't want to say was the framework, it's not evolutive. So it can start as non-contestation, but when the discursive level reaches a degree where you don't really argue about the norm anymore, about if it's valid, if it's applied right, if it's interpreted, was interpreted right, but it gets more substantial, at some point you cross over to challenge the institution. So of course the analytical framework is not clear cut. You can't say, okay, it will always remain non-contestation, will never go more, because I think in most cases it moves. But I'm not that familiar with the discourse in Argentina at the moment, but I think it's very likely that those cases, when they're getting public attraction, will get more into the like challenging the court as such. I think the others were all on. So factors of resilience are of course very important. I think that's also why we need more comparative research into the European example, how institutional resilience is analyzed there. I think the others are all.
So I'll stand up because otherwise I won't, because I'm in a very weird position. So the ideological problem, so the US is not part of the court, of course, but what we have is, although the Commission also although the Inter-American Commission can also sometimes shield the Inter-American Court of Human Rights from some of the heat, because basically it takes the issues that are like happening right now that states feel really strongly about, and these issues sometimes take about 20 years to reach the court. In the worst of cases, what the Commission does can also make states decide to withdraw from the Inter-American Court of Human Rights, because they can't withdraw from the Commission. They would have to withdraw from the Organization of American States, whereas they can denounce the American Convention on Human Rights. So they send a signal of some type, but they still have the Commission breathing down their necks. But they can always say, oh, the decisions of the Commission are not binding. So, yeah, there you go. Now, regarding the budget, I mean, there are so many different ways of expressing criticism, and the budget is one of them. And we see how Brazil used this very well after the Commission sort of stopped construction on the Belo Monte hydroelectric dam, because they had not consulted the indigenous communities living there. Basically, it stopped paying its dues in the years after that. So basically, we're just scratching the surface with this withdrawal thing, because there's just so much more to criticism and to contestation. And the fact that states kind of feel pressured to withdraw, positive in some respects. Basically, I believe it's because the framework of the convention is so deeply embedded into the constitutional structure of the state. So basically, if you don't withdraw, you will always have domestic actors that can make sort of basically bring these claims and always bring them back to you. However, that the court always has these very strong jurisprudence that tends to create these resistance and criticisms is, in my opinion, not always a particularly positive thing. Although, you know, my little liberal progressive heart sometimes sings it's a complicated type of thing. And the factors of resilience is basically it's the whole issue of these compliance constituencies, and the court is only able to withstand sort of these periods of extreme pressure because there has been a process of several decades in which this whole language of human rights and framework of human rights has been deeply instilled into the legal community. So that is one of the main factors of resilience, and civil society. Well, we can talk about that later. But in the strengthening process specifically, civil society was completely elemental to keep it going on. Thank you.
Thank you very much. So with this, we're still staying within the system of inter-American system of human rights protection, and we move to our second presentation. I give floor to Damian Gonzalez Salzberg, who is a full-time lecturer at the School of Law of the University of Sheffield, and also deputy director of the Center there for International and European Law. So his title is The Monetary Value of Suffering in International Human Rights Law, Empirical Study of Reparations for Non-Pecuniary Damage in the Americas. Please.
Thank you very much. In very, very brief, actually, what my paper will do is to examine briefly, this is a bigger project, but I'm going to examine or show what I examine the practice of the Inter-American Court when establishing reparations following a violation of the right to life, but actually a deprivation of life that amounts to a violation of the right to life. And I can explain this further on, but there has to have been a deprivation of life to fit within what I'm going to present. The first thing before I enter specifically into the paper is to keep in mind that when the Inter-American Court orders reparations following a violation of the convention, it tends to order 3 different types of reparations. If you go to the court nowadays, maybe find a few more categories, but in the traditional jurisprudence of the court, you used to have 3 different types of reparations. 2 of them are monetary compensation, compensation for pecuniary damage, and compensation for non-pecuniary damage. And then a 3rd group of measures of reparations that are non-monetary in kind, which have been incredibly diverse. My paper so far only focuses on this, on non-pecuniary damage, which is a tricky category because it hasn't been fully or exhaustively defined by the court. What the court tells us about non-pecuniary damage is that it includes the suffering and affliction caused to the direct victims under close relations, and we'll come back to the close relations later, and detriment to significant values and non-pecuniary alterations to the conditions of existence of victims and next of kin. So we don't have a full definition, and more importantly, we're talking about quite a complex task for the court. So if I sound a bit critical, I want to make a few caveats along the way, because it's obviously not easy for the Inter-American Court to quantify in monetary terms a harm or suffering that by definition is non-monetary. And this is what I wanted to explore, to try to understand then what is the criteria the court is using. And to be honest, in my particular case, I'm very interested in the Inter-American Court in particular, but I think that trying to understand reparations of non-pecuniary damage by the Inter-American Court is becoming more and more relevant for international law in general, because other international courts, such as the International Court of Justice or the International Criminal Court, are actually making reference to the jurisprudence of the Inter-American Court when determining reparations themselves. So I think it's very important to try to understand then what is the court doing for quantifying this non-pecuniary damage. It's important, and I mention it now again, and I will mention it in a bit as well, that the suffering that the court is quantifying for establishing non-pecuniary damage is both that of the direct victim, which in the case of my paper is the person that has been deprived of their lives, but also, and I would say since 1998, but this is contentious, but I would sustain that it's 1998, of the indirect victims, which are those close relations that the court was mentioning in that sort of definition we had. So it's not just the suffering of the person that has been deprived of their life, but also their next of kin, which actually leads to more complications. In the fuller paper, not even the one submitted, I also deal with what happens with the next of kin. Not at this moment, but I'm happy to discuss it later on. But let's keep in mind that it covers both types of victims. So this is now truly about my paper. This is the universe of cases covered by the paper I submitted. It covers 30 years of contentious case law, starting in the first ever contentious case decided by the court in 1987 up to the end of 2016, which actually only includes 85 judgments that actually have dealt with an arbitrary deprivation of life. And from those 85 judgments, it's only possible to know in 73 of them what is the amount of non-pecuniary damage established by the court. In the other 12 cases, we might have the court ordering global compensation for pecuniary and non-pecuniary damage. We might have agreement between the parties establishing a fixed amount for compensation. We might have cases in which, for security reasons, the court doesn't disclose what is the amount awarded to the parties. But only in 73 of them we know exactly. And actually, in only 69 of them, we can know the exact amount of compensation awarded by the court as non-pecuniary damage for the person deprived of their life. I'm going to show these very briefly in a few graphs. They're very easy graphs. In the first one, you can see the actual amounts awarded in these 73 cases. Each blue dot represents a case. They're ordered chronologically. And in the y-axis, you have the amounts in US dollars, since the court almost in every case has decided amount in United States dollars. And the first thing is quite interesting, or I found quite interesting, is the fact that the oscillations of the amounts in the different cases are quite big. But one of the main reasons has to do with the actual case law of the court. The court has dealt with cases that dealt, since its earlier cases, with one deprivation of life, but it has also dealt with very complex cases that dealt with massacres, with systematic practice of forced disappearance. So obviously, in cases with larger numbers of victims, the amount of non-pecuniary damage is much larger. So what I did is isolate then the amount of non-pecuniary damage awarded by the court in each case for a single deprivation of life. The first thing I noticed is that in some cases the amount awarded are different, and there are different explanations for this. And when there was more than one amount, what I put in the graph is actually the higher amount given by the court in that particular case. So again, we can see that now the oscillations are obviously a lot smaller, but you can see that, especially if you go to the right of the chart, you have two consecutive cases in which, in one of them, the court has awarded 0 for non-pecuniary damage, and in the previous one awarded about $800,000. One reason for these oscillations, but not the only one, is what I already mentioned twice. The fact that the amounts awarded by the court are not just to compensate the non-pecuniary damage or the suffering of the person that has been deprived of their lives, but also of their next of kin. So obviously, in cases in which a victim had numerous next of kin, the amounts end up being larger as well. So finally, in the third graph, we can see the amount of non-pecuniary damage awarded to compensate the non-pecuniary damage suffered by the victim, by the person deprived of their lives. And we can still see quite oscillations, obviously much smaller than before, but we can see, in particular, there's two cases, one that actually was just mentioned because it had to do with Trinidad and Tobago there, in which the court awarded 0 to compensate the non-pecuniary damage to the person deprived of their lives, and cases that have been, the amounts have been to $100,000 and higher. What I try to do then is try to understand as much as possible what is the reason for these oscillations. What can explain that in very similar cases, all of them dealing with an arbitrary deprivation of life that amounts to a violation of the convention, the victim might end up, or the family of the victim as beneficiaries in these cases, might end up receiving a very low amount, or a high one, or well, high or low in comparative terms, obviously, we're talking about life. The first thing is, I went to what the court says in its constant jurisprudence in all the 85 cases and more, that in order to establish non-pecuniary damage, the two criteria the court uses are equity as a general principle of law, and judicial discretion. The problem with these is that these are rather vague criteria that tell me, at least, very little as to how to justify those big oscillations. So what I did is I actually went case by case of those 85 cases to try to identify other factors that the court mentioned in some of those cases that it was specifically taking into consideration to establish the amount. So I identify actually 5 different factors that within those 85 cases appear at least mentioned once, some of them quite a few times, some of them was in the earlier case law and then disappeared. And then I coded these as variables and I tested them in a multivariate regression to try to establish the relationship in between these 5 factors and the amounts actually awarded. So the first one of the factors is the acknowledgement of international responsibility by the state. Especially in the earlier case law, the court tried to justify at a moment when it reduced drastically the amounts of non-pecuniary damage, saying we need to keep in mind that the state has acknowledged its international responsibilities. It has acknowledged its wrongdoing, which obviously is a very positive measure. So this appeared to be one reason, one factor that the court takes into consideration for establishing the amount. The second one that appears in cases dealing with minors is the vulnerability of the victim. Specifically in cases starting with street children, but in many cases in which the victims had been children, the court specifically mentions the vulnerability of the victim in order to establish then the amount of non-pecuniary damage. The third one, which is one of the most interesting for my larger research, now it was a bit tricky here, this is a very repeated factor, is the severity of the crime. But again, my paper is dealing specifically with arbitrary deprivations of lives. So the way I coded this variable, and this could be controversial, was to take a look at which were the circumstances in which the deprivation of life have taken place within these 73 cases at the end, because 12 of them we didn't know. And that leads to three alternatives. A summary execution, a deprivation of life within the framework of a forced disappearance, or a third alternative, which is that the deprivation of life was carried out by private individuals, but attributed to the state due to a lack of prevention. So these are the three ways in which I coded that particular variable. Then we had the length of impunity. The court actually now constantly says that the length of impunity is an important element, and I measured this as the time that lapsed since the arbitrary deprivation of life took place or the forced disappearance started, to the point where the court is actually quantifying the reparation. And finally, the number of victims. This is something that the court itself has not said. However, different judges of the court have mentioned that the number of victims in a particular case should be considered, and there are reasons why this could be a case. So, as I said, I did this, well, at least in this paper, actually I ran more than one model. We can discuss that as well later on, but there's no time now. I only have 2 minutes and 5 seconds. I did a multivariate regression with coding these 5 variables, and the results are that this model, accounting for all 5 factors, only 5 factors that were mentioned by the court in its case law, can only explain 28% of the amounts awarded. It's not that terrible. To be honest, I didn't know what to expect. I think that it's a very interesting number. Yes, definitely. But that leaves me so far with some ideas, some reflections which are not final. Again, I plan to continue this into other circumstances. Things are not that easy because the cases of the Inter-American Court, you're all aware, are a bit complex. It interrelates different rights and stuff like that. That's why I do the clarification that it's an arbitrary deprivation of life. And as final reflections, I have 2 possible alternatives. There might be others as well. One would be that there might be other factors that the Inter-American Court actually is considering but has not yet disclosed. And this is not so delusional, since my understanding is that the European Court of Human Rights does actually have guidelines. It has said it so itself, at least in one judgment. Many authors have said the same. However, we don't know, or personally I don't know which these factors are. So this is a possibility. Another possibility is that these are indeed the factors, however, have not been consistently applied throughout. This would be a more worrisome possibility. The truth is that there are others as well that are probably even worse. But since I only have 20 seconds, I leave it here. My faith is on the undisclosed factors that we might learn in the future. Thank you very much.
Thank you very much, Julia, for excellent presentation and also brilliant time management. So, dear colleagues, I open the floor. Oh, I have so many questions. I start with Lawrence. I think you were the first one.
So, Jamie, I'll be quick. I had a great presentation. I like the research design. I had 2 questions. One sort of small, which is, to what extent do you think that the monetary compensation, right, is it all one of the factors? In other words, if you already have a lot of out-of-pocket expenses that you need to pay for, then the court might decide, these the non-monetary ones, the number should be lower. So that would be something I would look at to see whether there's some implicit interaction effect between the two. The second is, you know, your paper is very nice empirically. I like the research design, but I want some sort of theory about what you think, what do you, even just at this stage, kind of speculation or conjecture, what do you think is going on here? I mean, because it's not, even if you could account for lots of different factors, okay, so if your R squared goes up to 80 or 90%, this is nevertheless still discretionary, you know, equity and so forth. So, you know, what do you see this as contributing to? What literatures or what claims are you trying to make? Or because I'd like you to go beyond just, look, I've been able to tell you something about this. That's valuable for sure in itself. But where does it fit into broader theories about what the Inter-American Court should be doing with its reparations, et cetera?
Thank you very much. Pierre, please.
Thank you very much. Yes, very interesting presentation. I have a question about vocabulary first. You talk about non-pecuniary damages. I don't know if it's a term of art.
The court.
In the court.
Yeah.
You know that the ICJ speaks about non-material damages in the ILO, notably. Because pecuniary damage, I mean, non-pecuniary damage has a meaning in opposition to pecuniary damage, but literally speaking, pecuniary damage means loss of money. And you have material damages that are not essentially, you know, your bank account being drained. So would it not be, of course you are focusing on one court and using the vocabulary of that court, but does it come from a translation out of Spanish or what? It's a strange expression, non-pecuniary damage, I think. And as you know, in the ILO, quantification necessary rests on equitable considerations. What else can you say? And my question,
and that's the
first criteria you put, which is acknowledgement of international responsibility, I presume the reparation phase follows or immediately comes after the merits phase in the same judgment. So if there is a merits phase, there is condemnation. When does acknowledgement occur, actually? Is it in newspapers? Is it acknowledgement regarding that victim? And is it really a valuable criteria? For the society, yes. For the victim, and I would have the same remark as Larry. I think the interplay between forms of reparation are probably a factor to explain the variation of the award. But again, domestic courts are very much used to that kind of issues, and they rely on equitable consideration, and they rely on a certain form of consistency over time, over the similar cases.
Thank you very much.
Yeah, thank you. One is actually a follow-up on Larry, and I would like to support what he has said in principle on the paper. I think it's very interesting. I don't talk about the theory thing now, because Larry has already said it. Maybe there's an interaction in between the different factors. So if you have like a lot of lapse of time and you're not allowed to that, how did you control for that?
It's accounted for because there's no collinearity in between the
There's
factors.
not. You control that.
Yes.
Okay. And then the second point concerning the undisclosed factors. You said you think it's more the undisclosed factors.
I'm hoping. I'm not saying.
I don't know. One possible undisclosed factors could be, and I wouldn't have written this article alone, but I call all that it was a court of the judge of the European Court, where we basically submit that there are punitive damages awarded. We don't call them punitive because we can't call them punitive, but de facto they are punitive. So in a way, you somehow account for this severity. But there are other factors which, at least from a social science perspective, when you argue for punitive damages, it's a sort of prevention. It's a sort of, this case stands for a lot of other cases which have not been brought. So those are undisclosed factors which you could put in. So I wonder how you accounted for those.
Thank you very much.
One more issue on the time lapse. Isn't this kind of an implicit interest rate?
No.
That's
well,
when does the injury, when is it measured? at the time of the judgment, I guess, for such a
Well,
major.
I'll come back to that.
Thank you very much. I have Bashak and then you have.
Thank you for this. It was very clearly presented as well. Maybe it will echo some of the previous points, but the question is whether the court is seeking some sort of a remedial balance, because the Inter-American Court has a lot of remedial tools, and it uses all of them in most cases at the same time. So the pecuniary, the non-pecuniary, and other forms of regulation, which are very diverse and very creative. So one, again, going back to the undisclosed factors, could be about other forms of regulation, that these sorts of changes may be actually about some sort of an internal remedial balance. So by looking at cases that they're non-pecuniary, we will not be able to see what is the sort of the balance that sort of is figured in a single case. So that could actually maybe help make sense of some of the cases.
Thank you very much. I take now a question from you, and then we will give you a possibility to answer once you still remember the question.
I roll down most.
So, thank you. This was very good, and I'm adding to others. But I would be interested to know what the parties have actually requested. I mean, there are hearings, reparation hearings before the Inter-American Court. So one clear explanation is that in some cases the lawyers ask for more money than in other cases, or put on the table some.
And the first to ask.
You're shaking your head. So
No, it's something that I have checked already, but I'll come back to that, obviously. No, it's a brilliant comment.
Okay, thank you very much. So you have possibility to reply?
Yes, I'll start from the last then. The parties, now you have access to all the documents in the majority of the cases, and you can see what the parties. The truth is that you don't know exactly how it's evaluated, but that was the starting point of my interest. Like I have worked with other types of reparations of the court and with preliminary objections, but my interest became of how do the victims know what to request to the court, and not just in terms of money, but also in terms of evidence, which is another part that becomes very relevant when you see the next of kin. Who is the next of kin and how you prove, and what sort of evidence you have to provide the court to then obtain the reparations. But the truth is that you see amounts and the court doesn't care much. The truth is that you see repetition of amounts, but at the same time, when you start accounting for inflation, because these cases have been decided in 30 years, then things get a bit like, I adore the court, so some things
However.
No, it's true. Like like I have been writing on the court for 10 years, and everything is with intention to improve the court. I think the court is the best thing that happens to my region of the world, and having like one specific president in that court was the best thing since Diet Coke. But I don't think the court cares that much about parties. I think the court makes its own mind regardless of what the parties are asking, and it's because many times the parties don't ask for. Sometimes the court mentions what the parties, especially up to 2007, you could see that what was the amount, and the court sort of mentioning the amount. From 2007 onwards it disappeared, so you can check it, but doesn't seem to be connected. As to interplay of the criteria, the honest thing is all the criteria I put there is the criteria mentioned by the court. I didn't want to start forecasting any other ideas of mine or anybody else about what is the criteria. I just went there to try to evaluate of what is the court saying that it's doing. That's why I didn't want to start dealing with the interplay of other measures of reparation. That I strongly agree with you that was my first passion with the court. It's absolutely amazing what the court does in terms of reparations and the consequences regarding compliance. Then with that, it's amazing, without a doubt. So yes, I think it could be interesting to think whether the fact that the court offers other types of reparations might have an impact, but at the same time, this is like what I check is what the court's saying and whether it sort of adds up. And the results are a bit that, not so much, but could lead to something like that. And actually, this is what pecuniary damage punitive damages come into play as well. There was a huge discussion between two presidents of the court as to whether the court can give punitive damages or not. They both won the discussion because The court doesn't award punitive damages, and one judge says that, but punitive damages are actually the other forms of reparation, so they are both rights. But in terms of money, the court cannot award punitive damages, and that was the decision of the court from very, very early. But then you have these other measures of reparations that might come into play. But they're not here. They're not in the pecuniary damage. They're not in the non-pecuniary damage. And I followed that because I don't remember if it was 99 or 2001, but around then, the court changed its the way it labeled this. It used to be moral damages. It adopted non-pecuniary damage, and this is the language of the court. So I go with that. Interest. Actually, interest rate is only awarded for delay in the time.
Exactly.
Yes.
But the damage, of course, has been done before.
Yes. In that case, no.
But the evaluation of the damage takes place at the moment of the judgment. That's why they still
Exactly. So it's an implicit interest rate.
Yes, well, rather than implicit interest rate, I think it's an implicit deflation, because the problem is that the court is amounting of damages at the point. Yes,
That's
it
the
could
same
be.
thing. Sorry.
Yes,
Well,
yes, yes,
it's
yes.
a factor.
But no, I accounted for that in the sense that I have the second model I ran, I didn't have time, is with deflating amounts. I turn all the amounts, but with problems, because I used the US labor secretary calculator to amounts, which actually might not be exact because these compensations are paid in different countries. And I ran a deflated amounts model to see if this was any difference, and the conclusion is that if it's not 28%, I think it was 25 or 26. So even if we take into consideration this, because the court takes into consideration the deflation of money, and that's why it awards compensation in dollars and not in domestic currency after what happened with Honduras in the first cases. So there is an awareness of that, but it doesn't change the result. The result ends up being in the very, it changes the p-value of one variable, but that's it. Like the full result is basically the same. So when the acknowledgement takes place, this change in the practice of the court with the rules of procedures, the court used to have 3 different stages: preliminary objections, merits, reparations. Nowadays, with one exception, since the 2000s, is only one time, but there are hearings. So the state has the possibility, and also can do it in the written pleadings, can say that we acknowledge that we have violated, and this is done quite often by the state. And at least at the beginning, the court has said this is something to keep in mind, because it's important that the state is coming here, not justifying, as Peru used to do, sorry, but that was the case, that yes, we massacred a few thousand people, but sometimes we need to keep the regime. No, the states tend to acknowledge their responsibility, which is a really positive factor. Again, probably not for the victim, but I think in terms of society, having as a non-pecuniary damage that the state official has to give a public act of acknowledgement that the certain parts of the judgment have to be published, are relevant. But if we go for what happens, the court has said it's relevant, but the numbers don't say it's relevant. And actually, with certain problems, it says quite the opposite. So, but I don't want to enter there. As to theory of reparations, yes, I think that's something I need to get into. But again, my original perspective was I want to see what the court says it's doing, and that's why I don't want to add other factors unless the courts or judges disclose them. But I think it could definitely benefit on theory, and I'm more than willing to take suggestions on literature and stuff. I think that's more or less it.
Thank you very much. Honestly, I had a temptation to abuse my power of moderator and also ask you some comparative questions, because I know you
I want to ask you comparative questions.
Okay, we can continue the discussion, but yes, time is running. Thank you very much. It was very interesting. And we now move to our final presentation for today, to completely different area. For me, to be honest, for me, it was really eye-opening. And we will now listen to Emma Nihan, who is PhD law candidate at the European University Institute, and prior to this she spent a number of years working in civil society in Ireland, Israel and Belgium. And she will speak about fate of Bedouin in Israel. Emma, you have the floor.
Okay, good evening. I'm going to try and do something, and I'm going to try and do my presentation in 12 minutes. That's very hard for an Irish person.
We appreciate.
Okay. So, in a way, I do feel we are coming full circle, and I do feel I'm coming back to the original keynote speech, which is nice. And just to remind ourselves of what the title of the conference, International Law in Times of Disorder and Contestation, arguably. After the times, you could put a bracket and have places of disorder and contestation. And that speaks a little to Anne van Anken, you raising this point about the geographical. We dealt a lot with the temporal dimensions of disorder and contestation, but there's also a geographical dimension. So, you've also noticed I'm not presenting the paper that's actually in the handout. This is the last presentation before my defence on the 25th of April, so a good excuse. So what keeps me awake at night and what keeps my oil burning? I'm really interested in how global knowledge of concepts and categories of international law happen, how that happens, which is quite an ambitious project to try and work out how a concept like indigenous people, can you hear me? Okay, I'm very soft-spoken. So how a concept like indigenous peoples is produced, it's generated and then circulated in context. The scholars I speak to are the likes of Benedict Kingsbury, covering the international law dimension. I'm quite enamoured by Samuel Moyn's work, The Last Utopia and the History of Human Rights, because I'm looking at kind of the history of indigenous people's rights. And when was the aha moment in indigenous people's rights? Was it the time of the UN Declaration? Was it the time of Grotius? You know, where does that time begin? And then I also talk a lot to Sally Engel-Merry. So I attach myself to the Law and Society group, specifically the legal anthropologist. It's a very small pond. You're more than welcome. So what do? I ask a law question. How does a concept and category of indigenous peoples become active and effective? And I don't just rely on law. I go out there, you'll see a picture in a moment, and I kind of see how that happens. So I end up reading books to get the doctrinal stuff, and I end up reading peoples and situations and one court case in my thesis. So this paper is really about the minutiae of international law. It's the little stories, it's the little men, it's the little women. And borrowing a bit from Bourdieu, who influences me, and I think of like the force of law, but I also like to think of law as a creative force of law or the reflexive force of law. And even, which I'm not sure if this works, I'm a Hibernian English speaker, but even the humble force of law. I have to make one big caveat. I don't answer whether or not the Bedouin are indigenous. That's not my area. Actually, domestic scholars in Israel are very good at trying to answer this question. So recently, some of you might have received an email about the latest contribution by Sandy Kadar, Oren Yiftachal, and Ahmed Amara. And what they're about is the legal geography. I'm less inclined to stick with the legal geography. A conflict zone, when we look at territory and lands, it's quite a complicated situation. And I actually end up using the word terrain, which is also a playing field. So I play with territory and lands and I come up with terrain. So I don't answer that question. And then one clarification, and this is a legal anthropology vein pumping in me. I don't use the nation state, and be that Israel or Ireland, as my point of departure. In international human rights law, I see it as one of the many contexts. So in my work, I don't focus on the state of Israel specifically. It's a context where the concept and category becomes active and effective. So this brings me, and I've 5 minutes down, to, so, sorry, I'm not the most gifted. Okay, so, I'm talking about, yeah? Sorry. Okay, yeah, perfect. So, how does the concept and category of indigenous peoples become active and effective in the Israeli Bedouin context? There's a group of Bedouin at some kind of a demonstration, and they're saying no to demolition and yes to recognition. So the Bedouin in Israel have a complex history and presence with the state of Israel about the land issue. So is it the 200,000 Bedouin living in southern Israel, the rightful legal owners? Or is it the state of Israel who holds 93% of the land? This is why a lot of scholars focus on the legal geography, because of the they see it as a land conflict. I'm trying to bring the more human dimension into this conversation. And I'm also trying to see how the concept and category actually unfolds within a broader context than just the territory of the state or the lands of the Bedouin. So my point of departure is really international human rights law. And those of you who work with indigenous peoples' rights might be familiar with this. And this is the international definition of indigenous peoples. It's from 1986, so some people will have been born before then or quite young. And it was written by a special rapporteur called Martinez Cobo, the Cobo definition. And I use this definition, and people often say to me, you're using the wrong definition. So for a lot of international human rights scholars, we can get more enlightenment, we can go further with the African Commission's definition that's broader. But this is the most commonly used definition. It took this man from 1972 to 1986 to write it, which says something that it wasn't something that was written overnight. And you can see that I've highlighted two parts of the definition, and one being the historical continuity with pre-invasion and pre-colonial societies, and the second part being down at the end, and it's the self-identification. Now, unfortunately, if I'm sticking to my promise, I don't have time to go into why they're so problematic, but just let's say history and identity are complicated in a space like here, okay? So to see where the historical continuity, who was here first, no problem. Was it the Bedouin or was it biblical Israel? And then self-identification, and I'll come back to this slightly at the end, okay? So I'm not giving up totally on this definition. And then you have a beautiful UN definition, and guess what happens? You place it in context. It's magic, okay? And that's how international law works. But does it really? I have one court case. It was involving a Bedouin village. Some of you are nodding, knowing the case. A Bedouin family or a couple of members who had a history of like acknowledging that there's rights out there and to fight for them, were brave enough to file a court case saying that this disputed lands, is their land. These Bedouin live in what is called an illegal village, what civil society likes to call an unrecognised village. So even the terminology is very loaded here in this context. So what I do is, most of you in the room are familiar with the notion of legal transplants. Alan Watson, we all know him. We've read him. But what I kind of try and do is shake the ground a little, take a deep breath and say the vernacularization of human rights. So it's in the corner here. And some of you might be familiar with, so vernacularization you can replace with transplant, okay? what I like about vernacularization of human rights is Sally Engel-Merry comes up with these 3 flows of how international law works in practice, okay? So her book is Human Rights and Gender Violence, Translating International Law. And the first part is about transnational consensus building. So if we go backwards, we can see at the international level, we have the UN busy bees making their international definition. Then we have the transnational program transplant, where NGOs are very active in transplanting this to here, the Negev, okay? And then last but not by no means least, we have the local realm, where the localization of this transnational knowledge of the concept and category of indigenous peoples. So this is a very innocent diagram, Venn diagram, and what I do is I look at Sally Engel-Merry's idea of how the concept and category is transplanted, how it is vernacularized, and it's a lot more complex and it's a lot more interesting than we'd have believe. So back to my paper. So this is where I actually have tried to map the concept and category of indigenous peoples that was made in 1986 at the UN. And then I tried to see these moments that happened all after the turn of the millennium. So I won't go through the list because I think I am actually over time. But in 2003, the very first line, the grassroots activist, Chaya Noach, who's in the Negev, met this woman from the UN who said, guess what? If I was you, and if you're working on the Bedouin in Israel, and if they're having problems with their land, I suggest to you that maybe you could go with indigenous people's rights. So this is one of the aha moments. Nothing exciting. It wasn't about Mabo in Australia. It wasn't about the terra nullius doctrine. And actually, it's so fascinating. So I do a lot of interviews, and when I met Chaya Noach, she actually nearly speaks word for word some of the stuff that Sally Engel-Merry's writing. She talks about the Bedouin trying on the concept and category of indigenous peoples and dropping it off, which is actually the same thing as what Sally Engel-Merry does. So in this paper, I spent a long time, and I'm sorry for the length of it. There was pictures that made up for it. So I introduce the events and the actors. And then I get into the more complicated situation. And this is me trying to work out how has the concept and category of indigenous peoples made by Mr. Cobo in 1986. What does Aziz Al-Touri say about the concept and category of indigenous peoples in 2015? I don't ask that question, are you indigenous? Suicide for an anthropologist, and it's a leading question. But actually, Aziz is from the village where they took the case. He actually has quite a strong knowledge of human rights. But then when I ask him the tricky questions about, so you say you're indigenous, hey? So what is that? And ultimately, and going back to the keynote speech, he says, I don't dream about international law. And he puts it back on me. So that is just an introduction to my work. If you want to read more chapters, you're more than welcome. I do find this research project is quite bigger than me, and it's very complicated. But I do think it tells a really important story about how international human rights law, how it's actually being generated and how it's working. And maybe it's something that more lawyers will come and join me and do. Okay, thank you very much. And safe journey.
That's really fascinating, and we already have the first question. No, it's you.
Okay, first of all, very interesting. I will note that when I worked in the Ministry of Justice, it was the point of time when the Al-Rakabi family filed the petition, and we investigated quite a lot the issue of whether they are indigenous or not. You will not be surprised by the answer of the Ministry of Justice. I will not go into the specific of the definitions, because that's not what you're doing, but I will say that in comparison to Oren Iftachel's opinion, there is a different historical narrative, and both historical narratives are fighting in accordance with the definitions of indigenous people, either the Jose Martinez-Cobo definition or the ILO 169 definition. But in relation to your research, you're examining how an international definition is applied in a domestic context and bring about a change. And I think that in the Bedouin case, it did not bring about a change. The Bedouins have been recognized as indigenous by several UN agencies from 2003 and onwards. And I sat with James and Ayad, the special rapporteur, dealing with this issue, and asked him, when you decided to recognize the Bedouin people as indigenous, what were the criteria that you applied? What was important for you? And his answer was, they view themselves as indigenous and they are marginalized. Okay? So those two criteria have nothing to do with the Jose Martinez-Cobo definition, nor with an ILO 169 definition. So it is allegedly a situation where an international definition serves a domestic population. But at the end of the day, it is a framework. If indigenous law is a framework which helps the Bedouin people, but it is not done through the definition which comes top down, it is a new definition, rolling bottom up. And this is today the whole tone. This is how indigenous law lawyers view the question of who is indigenous people. It's easier to say if they view themselves as indigenous, they are marginalized, they are indigenous. And this, I think, is dangerous, because we need definitions in order for them not to be misused. This is used in a situation where many view as positive, but it can be misused. For example, the Mapuche in Chile, where terrorism laws are applied against them by misusing the lack of a good definition.
Thank you very much.
Yeah, thank you very much. Fascinating presentation that I like very much. It's also much about kind of human rights advocacy in a way, and what it can do and what it can turn around in a local place or not turn around in a way. I think that if you put human rights and indigenous people and indigenous rights together, you could greatly profit from, in a way, explaining that earlier on the rights of indigenous people were not really taken on board with the classical human rights approaches. And also I think your discussion about the definition, the Cobo definition and the other definitions which evolved afterwards, and as you know, the DRITS does not really contain a definition. So in the most kind of authoritative UN document, we don't find even a definition to that, resulting, for instance, that we now have in Indonesia more than 800 indigenous groups, as you might know. So there might be a problem, but rather than discussing it substantially, I would like you to ask you what in your mind would be the authoritative body to decide on the question of indigeneity of a given group. So we are always discussing it from a substantive side, but we had research done in Göttingen where we can show that you can, in a way, window dress almost any group in the world to be indigenous. So I think the point is you can turn it to the procedural side and say who is the people to take the definition and the decision, and what would you think about that?
Thank you very much, and I have Pierre.
Thank you very much. Fascinating presentation. Thank you very much. I don't want to kill the magic, but somehow it's what you are describing is fairly usual in law. We have a qualification, we have a category, we try to fit the category, and it's a means to an end. I mean, we want to trigger rules and the benefit of rules for upholding certain claims. And that's quite banal in a certain way. Now, what is not banal, probably, is the intertwined relationship between the representing, the person coming with the ID, the represented, and how this relationship between the two make the self-representation of those that are at stake change. And that is probably the magical side of law. But for the rest, it's quite, I mean, you know, we open and close drawers, and on those drawers there are stickers with words, and we open or close them. And whether it fits or not, that's the matter. It's quite usual. But are you, it is this issue of self-representation that you are finding magical, or it is the simple fact of triggering a regime through a category, through a qualification that you find magical?
Thank you very much. Emma, you have your 2-3 minutes to reply.
Okay, you can hear my voice?
Sure.
Yeah. Okay, so this is the really difficult part where I have a concept and a category or the definition. And it's a bit like God, you believe in it or not. I don't, the concept that the definition that we have on the PowerPoint, it really only becomes real when we flesh it out, okay? So, sorry, your name? Okay, so your question is brilliant, and I would love to have talked to you before my PhD or during. So in a very pragmatic way, I would say the Bedouin are flogging a dead horse by using indigenous people's rights. I would suggest the ICCPR Article 27 minority rights might get them a bit further, being a cultural minority within the State of Israel. And, you know, I think that's a lot more easier, you know, even you're agreeing, or even, you know, dignity. I know there the court case in about 2012 where, you know, one of the legal centres in Haifa tried to push collective dignity. The time wasn't ripe, the courts held in the Supreme Court. It was on the Nakba law. But, you know, even within the structures, and then I'm just asking, sometimes is it actually a good idea to go international, you know? So that's kind of like, you know, and about Anaya, you know, Rodolfo Stavenhagen, James Anaya, these are the metal, putting the rubber stamp to answer your question, where is that procedural thing happening now? And, you know, they're human beings, they have academic backgrounds. Stavenhagen was an anthropologist, Anaya was a lawyer. They approach it very differently, even the subject matter, you know? So that's to address the first thing. Human rights and indigenous people's rights, and is it better to be more human than indigenous? And, you know, indigenous people's rights really only took off in the 3rd generation rights. And, you know, and this is where, like, I disagree with Oren Yiftachel and Sandy Kadar and Ahmed Amar somewhat. They see this terra nullis and this Mawat, which is a Mawat law, which is from the Ottoman Empire, and they make a comparison, comparing them like apples and oranges. And I'm like, maybe you're comparing apples to tomatoes, you know, that there's something there that doesn't quite resonate with me. And they're very much pushing the idea that the Bedouin are similar to the Aborigines in Australia. Different history, different context. Settler colonialism is settled in Australia. When you're asking who is indigenous, you're also asking the converse question, who is a settler? And that's a difficult question. It's not really hard answering, are they indigenous or not? The more difficult question in some contexts is answering the converse question. So, yes, and, you know, 2007, the UN Declaration on the Rights of Indigenous Peoples was passed. They decided not to have a definition. Surprise, surprise, it was too difficult. And what we saw last year was the 10-year anniversary, and that was a bit of a whimper. So has the momentum of Indigenous people's rights, once they got the declaration, what has happened there? So substantively, like, you know, the substantive issue and the procedural, well, at the moment, the UN Special Rapporteurs on the rights of Indigenous peoples are giving the rubber stamp. So they're, you know, they're the top dogs. The paper that I wanted to present is the transnational organizations. So these are transnational indigenous peoples organisations in the UN in London and Copenhagen, and they're coming up with what I call transnational lists. So look, like you have global indicators, you have transnational indicators of who is indigenous or not. And by getting into these the reports of these transnational indigenous peoples organisations, you got a degree of recognition there. Yeah, listen, I'm just a total optimist. I look for the good in everything, everyone, and even in international law. I think the magic about what I love about what I do, it's not the representation thing, but it's like the fuzziness, the messiness, the methodology. Like, you know, when I'm looking at my question, I often say, how can I best answer this question? What tools do I have? So in my study, I actually only use the Al-Araqib case because that's the only case in the state of Israel where the claimants have put forward a claim to being indigenous peoples and the rights that come as indigenous peoples. So for me, the answering that question is a very big part of the magic. It's a lot of hard work as well. And does hard work make magic? No, I don't think so. But in some ways, I would have loved to have done a doctrinal PhD thesis. It would have been a lot less headache. But yeah, you can make this sound fantastical and you can make this sound very everyday. And actually, that's kind of the humility, the humbleness, the ordinariness, how international law and daily life meet. That's it.
Thank you very much. So now I'm happy to invite for final comments, conclusions, and propositions on all these three brilliant presentations. Our dear Vice President of the European Society and member of UN Human Rights Committee, also Professor of Public International Law in Athens, Fotini Pazartis.
Well, hello, thank you, Chair. After the final remarks of Emma, you know, I'm already starting to sort of quaver and maybe want to throw all my papers away and become very, very emotional, but I won't. I'll try to keep it
sober.
Sober, I wouldn't say lawyerly because you'll probably kick me out. So I'll try to just try to avoid lie even though I can't in addressing these three excellent, by the way, excellent, not by the way, presentations on three very interesting, extremely interesting topics, especially Emma's, which is something that we're not very familiar with. We know about indigenous peoples, and I will come back to them. Lawyers know something about them, but we got an anthropological point of view. Now, if you allow me, Chairman, I would like to sort of change the order, so bring some disorder in the forum. So I won't start by the first speaker, but I will start by the last one because, like I said, she just moved me so much that I have to respond. So I would like to, first of all, after congratulating again all three, and after saying that these three papers, all of them, are based on empirical studies. And this is very interesting and very important. We tend to forget it, you know, the older we get because we don't have time. The last time I spent time doing empirical studies was in Cujas Library underground, looking for treaties, you know, for 5 years, only to have my professor at the end told me, but, you know, I told you so. But that was my thesis. I had to do the empirical work on finding, you know, dispute settlement clauses. Anyway, so all of these speakers here and others in the past 2 days have done very interesting empirical knowledge. I will come to Damien, you know, because there I want to cut my wrist. But anyway, but all of them. And this is very interesting because it adds to things we might know or we think we might know. And maybe the perceptions that we have, me as a lawyer, and I might be willing maybe to change or take other considerations into, other factors into consideration. So I have to congratulate them for that. I was trying to find a linking of these three excellent papers because I had to do the conclusion, unfortunately. I'm not a chair, but I have to do the conclusions. So, and I just wanted to flag two general issues. First of all, I want to flag the approaches of the topic of the theme. And secondly, I want to talk about what I gather to be one issue that seems to sort of be transversal, which is a question of indeterminacy. So, coming to the approaches, now we have different approaches. That's why I wanted to start with Emma, because I think it's one of the few approaches that is non-judicial, adjudicatory or judicial. So we just get really, human rights, something. I mean, some substantive approach. So Emma treats what I think she says somewhere in her paper, contested indigeneity. And so it's something having to do with contestation. Now, Emma does not answer a question which for me is interesting, but then again, as a lawyer, maybe I'll try to change my opinion. Can we approach this topic without defining indigenous peoples? She's very persuasive in saying the way I'm approaching it anthropologically, I don't need a legal definition. But it muddles me because then I am a lawyer, and I'm thinking, well, if it's a person that is self-identified or is marginal, then why is it not a minority? And why do we need, for example, to qualify, and why have NGOs or international people moving around international human rights fora? That comes to what Tobias Stoll was saying. Why have they come up with this concept for this particular case? And why not a different one? You answered it in the beginning by saying that you're approaching this geographically. Yeah. Because it is a way to approach indigenous peoples. You approach them geographically. I mean, they're somewhere. They're tied to a land. And while property issues might be too legal for you, and for me too, I don't want to put it up property-wise, but they're tied to something. And the way any individual self-identifies is quite important. Okay? So there's a difference between indigenous peoples and others. Okay? Even if it's in the self-identification, but it does give, it leads to certain different rights from the ones that, for example, saying I'm a minority or I'm a people, because the ICCPR covenant in its first article, if you don't go to Article 27, you could go to Article 1. It says, people. Now, Damien, I'll come secondly to Damien on this first approach of approaches. Damien treats the disorderly quantification of monetary reparation for moral damages. Call it non-pecuniary damages. So again, we have this issue of this, it's quite a disorder. Okay, I will come back to that. It's of course a topic I am very interested in generally and specifically, but I will come back to that on my second part. And Jimena and Sylvia, to come to Jimena and Sylvia, want to define backlash. So here they wanted, and they define it as a gradation, and I left them last because I think their paper actually ties in with the Magister course that we did at the beginning. So there's a lot of things that are parallel, that are running parallel. So I wanted to treat them maybe in the end separately. They have differentiated, they have given all of them, of course, they also have based their work on empirical analysis of the 3 or 4 cases we know in the inter-American continent. Excuse me. So they have moved from softer to harder. They say that backlash is an umbrella term, and I'm wondering whether, coming to the end of this conference, and going back to what Larry has said, we can really strictly identify types of backlash, or use it as an umbrella term, but then go to these various notions that you use, because they are, each links with the other So it's quite difficult, a difficult task, I think, to separate all these from the softer to the head-on backlash, or what Larry called the cooperative or the hostile approach. Okay, so these are three approaches. These are the way. These are maybe a way that we can tie in these three papers. Now I come to the indeterminacy of various concepts, and this is a little more interesting. It could be a little more interesting, because maybe, and here the political scientists will help me. I'm not, I don't have the tools, but maybe this indeterminacy of the various concepts we've been hearing about the past 2 days might be part of the contestations themselves. So I don't know if I'm making sense. Anna will have to sort of, hit me if I'm not. But because I'm trying to figure it out, because I'm trying to figure out whether we can generalize, okay? I'm trying to figure out whether we can find the answer to your question, because it's an art of a judge. I believe in judges. Sometimes, I don't like them very much. But I mean, it's how can you quantify, how can the French say réparer l'irréparable? For human rights violations, this is it. How can you do it? And so your approach is quite interesting in trying to find the pecuniary way of doing it. But can you quantify in monetary terms, can you quantify moral or non-pecuniary damage? And if you can, which I concede that maybe you can because you've done such research that really, chapeau, I haven't done it. I'm just sort of extrapolating. But if you can you do it without looking transversally to other remedies? Because in moral damages or non-pecuniary damages in particular, this court has been very advanced in using what we would call the satisfaction, the third category you have. So here I would need, maybe there's an indeterminacy that could be really actually quite easily solved when you look back into the theory. Now the concepts themselves, and Pierre Dajan was saying it, are elusive. What is moral damage or non-pecuniary damage? You chose the right to life. Of course, it's one of the most fundamentals. I don't want to complicate your life, so I won't say, but why not other violations? Because, you say yourself, but the court actually has many violations and many people to deal with in one case. So maybe some of that we would need some clarification. Now and of course, who are the victims? And here I would like to ask, my only question was, do you think there's a gradation of reparations when we have very serious violations, as is the violation of the right to life? And I won't answer that. I don't have an answer to that. And I will come to the third indeterminacy of my lovely colleagues, Sylvia and Jimene. Now, to answer your question, which was also excellent and very well put, I think we would probably need some more, I don't know who said it in the beginning, but we need some more explanation of the factors of resilience. There I was it was cut short. Maybe you're, yeah. No, even in the paper, because I read the paper, I had to. So and I did. No, and I did. I didn't have to. I loved reading all but I wasn't satisfied on the responses of the resilience. You bring in the three factors, and I think somebody also brought it up that there I need a little more, and it might help me get, have a clear, or it might help anyone reading your paper, which is excellent, have a clearer picture, and maybe help judges who are trying to quantify and have not quantified. We hear they have some secret ways of quantifying. We hear it. There's nothing published. I have no insight from judges, so I have no idea. You will abstain, I'm sure you will abstain. But a word is, that, there are some some principles somewhere there, but I'm not sure that these principles are actually, you know, guidelines that are really followed. And I will come to what I was telling Damien, you know, it's an art as well. You have to be a lawyer, and everything is an art. You know, you have to be, you said you are... a legal anthropologist? No, yes, but you were an optimist. I'm an optimist too. But, you know, some things have to be clarified. So in your case, vernacularizing the concept, I'm not sure it would, you know, help. Because I think the last person that you spoke with, or the one, he said, I don't read international law. That was an interesting response. Did you ask him about international law? Because his response could have been, I feel that I'm, you know, he said, I don't read international law. So were you asking him, do you feel like you're an indigenous according to this definition or not? Anyway, but I think that this is the, maybe what we can get from this conference and from the papers I read, that maybe this indeterminacy can lead us to, you know, really finding some fascinating answers, even for lawyers who are so boring. So I thank you, and I'll end with that.
And with that, I think now I can invite Yuval for closing remarks.
Yes, we have decided jointly to amend the schedule, not to take a 30-minute break and then go to closing, but actually segue directly from this very interesting and exciting session to the closing statements. So I will say a few words, and then I will invite a few others to say a few words, and then we shall close. So, friends and colleagues, it's time to close the 2018 ESIL Research Forum in Jerusalem. So we're very pleased everything went smoothly, and I believe that on top of the very good, time-sharp academic exchanges that we have had, I was also very impressed with the very congenial atmosphere in which all discussions took place, and I think this was a very conducive to early career, but also to mid-career and late career professionals that are here, and everyone can classify himself or herself in the appropriate category. So that's a self-identification exercise. So I really want to, before we go into some official business, I do want a round of applause to our four very effective organizational team. Tal, André, Yarden, where is Yara? Excellent, and I also want to acknowledge in the same connection the organizational and moral support of ESIL. Thank you very much, Joyce, and thank you very much, Louise. So I will now invite Louise to say a few words. After that, I will say a couple of words on publication and invite some others to speak, and then some closing remarks. Louise, you have the floor.
Well, thank you. After these intense debates, I will not occupy much of your time with a long farewell speech. This has been a very interesting research forum with very high quality papers, with very thoughtful debates. That's what usually happens when you select 1 out of 20 abstracts, and then you have always high quality speakers. All the speakers can be very proud to have gone through this selection process and to have made it until here, and therefore we have very high quality papers. I was going to thank each of the members of the organizing team, asking you to give a big round of applause to each of them, but let me say that we will thank the team again, including Yuval, for the brilliant organization of this research forum. I think that the European Society of International Law is indebted to Hebrew University. You have done things so well that you have even fixed the weather. Because when I came here on Tuesday morning, it was raining cats and dogs, and you immediately fixed it, and we have had sunshine during the whole conference. Well, the next ESIL conference will take place in Manchester between the 13th and the 15th of September this year, dealing with international law and universality. In times when nationalism is rising in the present world and is questioning core elements, some of the core elements of international institutions, some of the core elements of the international legal order, the issue of universality is particularly topical. I think it's particularly relevant. And if any of you still believe that international law has evolved from a law of autonomous sovereigns to a law of an integrated world community, you really have to rush to Manchester and defend it. You can have a look at the very interesting program already online, and you can already register because registration was open last week. Well, everybody knows that Jerusalem is one of the oldest cities in the world and carries the heavy weight of a rich history and of a complex history. International law has played and should continue to play a key role in the future of this city. Its old city is one of the best known World Heritage Sites, and ESIL has been delighted to hold its 2018 Research Forum in this wonderful and ancient city. The ESIL board members will spend tomorrow morning, part of the afternoon, meeting in a room to solve the great problems of mankind and some of the bureaucratic problems of this society. The rest of you can meanwhile enjoy the city. In particular, the organizers have put the cherry on the cake and will bring to a perfect ending this research forum with a visit to the Israel Museum, which is one of the most stimulating sites of this city. So please enjoy it on behalf of the board. I hope to see you all again in Manchester later this year. Thank you very much for attending, and thank you very much for participating in this wonderful event.
Thank you, Louise. A few of us have asked us about publication options for papers for this forum, and we did discuss this briefly, but we thought that in the interest of clarity, we will invite the three editors who are here to say a few words. So I would like first to invite the ESIL SSRN editors, Christina and Pierre, to come and say a few words about how is the process for submitting to the SSRN series, and then I will ask my colleague Yael Ronen to introduce the Israel Law Review option.
Thank you, Yuval. I'm happy to say that what I'm going to say is not complex, but very simple. So you know the Society has a SSRN series, and of course, in order for more people than those who very happily participated in our debates to take benefit from your contributions, you are most welcome to submit your contributions to our series. You have 2 months to polish, improve, take benefit of our debates, and submit those papers to us, the editors, Christina, Faye, and me, and we will be happy. There is a fairly slight peer review process. You will be duly informed of how to send by email your papers, but we would be very happy to receive them, and the deadline is 1st of May, which I think is the same as the Israeli Law Review. Thank you very much, and we look forward to receiving your contributions and your paper, because indeed I think they deserve not only this audience, but the larger one. Thank you very much.
So for those of you who don't yet know, I'm Yael Ronen. I'm the academic editor of the Israel Law Review, and that one's not complicated either. And I think the participants, the speakers have received an email that the Israel Law Review is happy to accept submissions. And like the difference is that we're a law journal. The Israel Law Review is published by Cambridge University Press for the Minerva Center for Human Rights here at the law faculty. And it's a journal of human rights, international, and public law. So all papers presented here definitely qualify in terms of topic. So you're welcome to submit, I guess, in parallel to the SSRN, because our deadline also the 1st of May. And if anybody wants to submit earlier, that's they're more than welcome. If there's a problem you want to submit later, be in touch with me. You've got my details on the email. There's going to be a follow-up one. Our peer review process is slightly longer because we are a peer-reviewed journal and we work on the basis of exclusive submission. But we try to provide responses positively and early as we can. So feel free to get in touch if you want further details. Thank you.
So just before we break away, does anyone still needs to announce something? Someone has lost something? So just a couple of substantive thoughts that I thought I wanted to share. So this is not a summary of the conference, but I think I would want to refer to two speakers. One who I want to refer to Bashak's opening remarks, and I also want to refer to one of Anne's many interventions. But I think that was the first intervention. So we heard a lot about pushback, and we heard a lot about challenges to legitimacy, and about the declining commitment to values, and perhaps the need to respond to these trends through new institutional designs. But I think we've also heard that there is a growing dissonance between what our project as international lawyers is, and I think Bashak defined that we international lawyers we don't do a lot of things good, but there are some things that we do quite good. And if I recall correctly, you talked about law adaptation and law resilience, studying law resilience, and also identifying law violations. And the question is whether, in light of this growing dissonance between what we do best and some other social forces, such as public opinion, such as the political interest of government elites, the changing technological, diplomatic, economic landscape, then the question that Anne proposed early on is, what is our responsibility as international lawyers in light of what appears to be the changing fortunes of our profession? Do we continue business as usual, building our castles in the sand, and perhaps disagreeing on how many turrets should there be on the castle and what flag should fly on? Or do we circle the wagons and basically go easy on international institutions because they are under so much pressure, so we should be soft on them? Or although we do know that they are maybe part of the reasons for disorder and contestation, do we seek to critically re-examine our own discourse and look for new ideas and perhaps new allies and new avenues for our normative mission? Do we even have a normative mission in a postmodern age which is reflected by lack of clear value hierarchies? And do European international lawyers have a particular voice regarding these issues? Should we dream about international law? Thank you very much.